and thank you for joining 4SA in our latest interview. Today we're going to be talking to Mr Pandelis Gregoriou from the Films and Publications Board. Pandeli, welcome, and thank you for agreeing to be interviewed by Freedom of Religion South Africa, commonly known as 4SA. Kindly tell us what it is that you do at the Films and Publications Board.
So I am the current acting regulatory development and enforcement executive, which in essence means on the one side where we deal with regulatory development, I'm responsible for seeing those instruments at the FPB that require either further amendments or in the space where those instruments don't exist, actually developing them from scratch. On the enforcement side, I'm now responsible for the work that our enforcement committee is going to be ultimately dealing with. And that's part of the expanded mandate of the FPB, and the enforcement committee in essence was introduced by the new amendments to the Act. So very much a start in the process in the enforcement space. It's a very new structure to the institution, but I cover both of those issues at the FPB currently as the acting executive.
So tell us a little bit, what actually does the Film and Publications Board do? And how is that kind of coming to the fore at this stage? Obviously, there's been some amendments to the Act, there's been some regulations, but just tell us a little bit about the work of the Film and Publications Board in the bigger context.
Perfect. So in terms of our mandate, we are responsible for very much what we used to do in the past prior to the amendments coming into effect, very much a classification authority. So we would be responsible for the regulation of the creation, possession, production, ultimate distribution of film, game, and certain publication content. But with our expanded mandate that has been introduced by the amendments, we now also deal with certain instances where members of the public can lodge complaints with us. Those complaints, however, are limited to 3 instances where content that does fall within the definition of prohibited content has been posted on even social media platforms. They have the ability to lodge complaints relating to those instances, but also with private sexual photographs and films without the consent of the people in those private films and photographs have been distributed, but also importantly, where you do see violence against children and sexual violence against children being portrayed in any photograph and film. In those 3 instances, where content has appeared, it makes no difference whether it's a commercial distributor of content or a non-commercial distributor of content. Members of the public can still lodge those complaints, and we still now mandated to deal with those complaints as the Film and Publication Board. Now, in that space, it's still, even though those amendments have come recently into effect, with our regulations that have come into operations in early September, we are still getting very much our teeth into those provisions. And very quickly, we're going to be able to deal with those matters as well. So our mandate has expanded to deal with both of those instances, and that's what we're responsible as the FPB.
Okay, so that is quite a mouthful. I'm just going to recap. So the FPB primarily worked in classification beforehand. And maybe a question there after the recap is differentiate classification from censorship. But now with the expanded mandate, which came into effect on the 1st of March with changes to the Film and Publications Act, you're also going to be handling complaints from the public, and those complaints can happen on 3 grounds. So when prohibited content is online, so perhaps you could also look at what prohibited content is. When you have private photographs of a sexual nature or private videos of a sexual nature being distributed without the people involved's consent, and then violence against children. So people can complain to the FPB when any one of those 3 things is found online. So, Michael, you were around when censorship was a thing. Maybe you should tackle that question.
Yeah, and I think that's probably one of the bigger concerns is that, you know, obviously freedom of expression is such a fundamental aspect of any free democracy worthy of its name. And we have in this country lived in a context whereby so much was literally censored, banned. I can remember the most crude film cutting exercises where just as the person was going in for the kiss, there was a cut because we weren't allowed to see any such horrible things as that. But tell me, how has this changed? Because obviously the internet has changed a huge amount. I mean, everything is now going online, number one. And I guess control is therefore a little bit more complicated. But how is this differentiation taking place? And also, what is the protections, if you like, to ensure that freedom of expression does remain unhindered in as much as it doesn't break any laws?
So you've mentioned a very important point, and it's something that I've emphasized on a number of occasions with all our stakeholders, right? So the freedom of expression is one can argue confidently is the cornerstone of any constitutional democracy, right? So you should, in viewing any limitation to the right to the freedom of expression, you should have to do so within the constitutional framework. We have a limitations clause that provides for how you can limit the freedom of expression. It's an entire sort of process that is undertaken in making that assessment. But I can confidently advise that the Films and Publications Act does fall within that space. Firstly, it is a limitation of the freedom of expression, but in being constitutionally valid, it is within the context of what we are trying to achieve as the FPB, and why it is a legitimate limitation to the freedom of expression. So let's focus on that sort of classification part of our mandate and why that's important. The limitation, and you've mentioned something which we consistently see in all media reports. The Film and Publication Board is not the censorship board pre-democracy. We've transitioned into the space where what we do provide is information to our stakeholders, the public at large, and importantly, the public that has children in their care, right? And what we try to do is by classifying content, and that's the role that we would play in the classification space, is we're providing information to our stakeholders as to firstly what appears in content so that they can make that informed decision. But importantly, when they're making decisions for children in their care, they can likewise make those informed decisions so that their children are not going to be exposed to harmful content. So in executing that mandate and where the argument advances that nonetheless is still a limitation to the freedom of expression, it is a limitation that I think falls within the constitutional frame of reference that allows for such a limitation. So we don't censor, we don't limit people's ability to access content. What we try to do is make and assist our public to make informed decisions, right? And I think that's very important. As we then transition into the expanded mandate, and I think Daniela has raised that frame of reference in particular, what we're now mandated to do in terms of those recent amendments, it is important to also take cognizance of the fact that even in that instance, an investigation still has to take place. So whether it's prohibited content that appears online, so even in the context of social media platforms, or you do have the distribution of private sexual photographs and films without the consent of the people appearing in those photographs and films being distributed, or where you do see photographs and films depicting violence against children or sexual violence against children, an investigation still has to take place. And it's only when that matter is ventilated before the enforcement committee, and the enforcement committee feels on a balance of probabilities that it does fall within any one of those three contexts, that then it becomes an offense, and then the provisions in our act will then kick off. So we cannot make unilateral decisions. We cannot make a decision without due process being followed. But I think in all three of those instances, you see that there are valid grounds why we would need to firstly investigate and make sure that where those issues do arise in any one of those three contexts, that we have the ability then to escalate that to the enforcement committee, which can make an appropriate decision when on the balance of probabilities we've established and proved the case. And I think, Daniela, you asked what prohibited content means. Do you want me to unpack that?
I was about to say, let me summarize what you've just said, and you can tell me if I've understood you correctly. So the classification function of the FPB is to assist caregivers of minors by saying, for example, that this film is PG or PG-13 or 16 or 18, and giving that rating so that consumers can make an informed choice. So it's not censoring movies, it's not withholding information. But with the expanded mandate that came into effect from March this year, members of the public can lay complaints when it comes to prohibited content for images and videos of a private sexual nature where the parties haven't agreed to being distributed, and violence and sexual violence against children. On those three grounds, they can lay complaints with the FPB. The FPB's enforcement committee will investigate and only then make a decision on whether or not that content is allowed to be made public or distributed. And those three grounds, in your view, prohibited content, images of a sexual nature, private sexual nature that people haven't consented to being distributed, and violence against children, they survive the freedom of expression test that it needs to survive to limit that right, according to the Constitution. So that brings me to our next question, which is the only ground there that could possibly affect freedom of religious expression might be prohibited content. So Pandeli, perhaps explain to us what prohibited content is in terms of the amendments that now came into effect back in March this year.
Yeah. So our definition for prohibited content in the Act includes, firstly, unclassified content on the one hand, but also includes propaganda for war, incitement of imminent violence, at what we colloquially refer to as hate speech, right? It's a long provision. It doesn't say hate speech per se, but would include how we would then assess hate speech. So it's in any one of those four instances that we would then assess prohibited content. We have a definition for hate speech in the Act as well. It is a very technical exercise because we don't term it hate speech in the actual definition for prohibited content, but you will find hate speech in one of the provisions in our Act, which deals with what falls within the context of prohibited content. So we're in the process of also developing a framework, a bit of an informative document that assists us in assessing what amounts to hate speech. And I'm sure you're aware of the fact that there's a lot of jurisdiction, a lot of jurisprudence around the topic. And as the FPB, as we're transitioning into that phase where we're dealing with such complaints, we will be in a position then to consider what amounts to hate speech within either the judicial precedent that has been developed, alternatively considering how our enforcement committee develops such jurisprudence. We're not there yet. We are still very much at the formative stages. We haven't as yet processed any complaints that would fall within that provision, but it is work that we're undertaking, and hopefully we'll be in a position to be able to deal with them substantively in due course when those complaints arise.
So Pandeli, turning to the prohibited content, you've hinted at two things there. You've hinted at unclassified content and content that is hate speech. I know that 4SA has been actively involved since the first changes to the Act were proposed, and then the draft regulations and so forth on the hate speech definition and enforcement that were proposed, because obviously our big concern is that offensive religious speech shouldn't be censored. And I know the Act makes hate speech a crime as well, the distribution of it. So we've been involved with the FPB and with the Department of Communication and Digital Technology since the very beginning, lobbying for a very narrow definition of hate speech that accords with the Constitution. But perhaps turning to unclassified content, what impact does the Act and the regulations have on churches and religious organizations such as mosques and temples who record their content and put it online?
So, and I think this is a very important topic of discussion. So in the question that you posed, it'll be remiss of me not to mention the fact that we also want to deal with hate speech complaints, right? Within the premise of the jurisprudence that has been developed by the Constitutional Court, and make sure that we then consider hate speech cases within that space, right? So we also want to deal with it as sensitively as we should. And I think as we deal with those complaints, I think the jurisprudence will even be developed a bit further, even though it is within our own enforcement committee. But the frame of reference will always be with the jurisprudence that has been developed by the Constitutional Court, so that we will always keep as a frame of reference. But importantly, in the second part of your question, again, it would be remiss of me not to also highlight a little bit of a technical point, that our Act, especially when it deals with classification, does distinguish between commercial distributors of content and non-commercial distributors of content. Now, in understanding what distribution means in our space and how the Act defines distribution and how content should be distributed, and again, without becoming too technical, it usually means that you have to consider whether there's a commercial transaction that takes place. Where there is no commercial transaction, you would then not fall within the definition of either distribution or being a distributor. And in that context, in the classification space, we would not have a mandate to deal with you as such, right? And I know inevitably the next question that you're going to pose, but what does a commercial transaction mean, right? And in our context, we don't look at it only in the context of whether you are, as a person who's consuming content, actually purchasing a particular title. So for example, let's say there's a particular title that you want to access, and in order to access that title, you have to pay a particular fee. But it would also include where you have to pay a particular subscription. And I'm sure you would be aware of the fact there's lots of platforms that are currently available online that you can pay a monthly subscription to access content. But importantly, it is even expanded to include where you don't have to either pay a transaction fee or pay a subscription fee to access the content, but where advertising may appear on the content in order for you to access it. So it's in those three contexts that we would then assess whether somebody would amount to be a distributor, and in then unpacking whether a religious institution or organization would fall within that definition. A lot would fall within whether the content that appears on a platform, whether it would be subject to a transaction, a subscription, or whether advertising may appear on that platform in order to access that title. Now, I know it appears very technical, but sadly, that's what we do. We look at it from a very technical lens. So whenever a religious institution wants to ask that question to us, those are the issues that we would bring to their attention, and dependent on whether they answer those questions in the positive, in the affirmative, i.e. whether a transaction has to be paid, a transaction fee has to be paid to access the content, or a subscription has to be paid, a monthly, quarterly, annual subscription has to be paid to access it, or whether advertising will appear on the platform, and in fact that also serves as a particular revenue for the religious institution, then sadly you would fall within our legislative scope, and it means the content would then have to be subject to classification prior to appearing on the platform.
So as you know, from a religious freedom point of view, that's really where our very narrow focus is, and clearly a lot of the things that you've mentioned should, please God, have nothing to do with religious freedom. If you're inciting violence, trying to cause wars, or showing horrible sexual images, or beating children, that's the last thing that would be on religious organizations or religious practitioners' minds. But that said, there are definitely a couple of areas where I think the concerns are raised, perhaps not necessarily for any other reason other than the unnecessary delays that can take place and the related administrative burdens that can take place. But I'll give you a couple of examples, and maybe you could then comment on that. There are obviously churches that record their Sunday services. Sometimes they live stream them, for example. And very often those live streams, they subsequently put up on a platform. It could be a YouTube channel, it could be their church website, for example. That would be one area which I'd like you to comment on in terms of would that be caught. And the second area is that there are some churches that actually have channels that they sort of piggyback on DSTV, for example, and they are in that sense broadcasting out their content, and often they're broadcasting out again live. It can be real time. How would that type of thing be affected by this censorship or the regulations that?
So you shouldn't use the word, Michael, censorship, because we don't censor. NB right there. But In the classification, yes, in the classification requirement for such distributors, right? So I think you've raised two very important issues. So let's deal with the one. So when content is being live streamed, right? So even if it is on a YouTube platform and you're live streaming, the FPB's mandate does not extend to either live streaming. So in other words, we do not regulate live content. Alternatively, if you are a religious institution that places your content on a linear platform, right? So you've mentioned one of them, could be others, any linear platform that is out there. We also do not regulate linear content, right? So in our space...
What? You tell me YouTube, Vimeo, that type of thing?
No. So in other words, where your content appears outside of a video on demand platform, so very much in the broadcast space. So for example, the easier way of assessing it is where I have the ability to watch the content, right, whenever I want to. So if I want to access the sermon, right, a religious sermon that has appeared, and I have the ability to access it whenever, wherever I want to, then that would fall within the FPB space. If it's in the broadcast space, and I think just to use another example, the moment I need to access it, and let's say I'm 5 minutes late, I just remembered that it is actually appearing at a quarter to one as a particular time. And if I'm 5 minutes late, I have missed the first 5 minutes. Clearly, that is not our mandate. That is the broadcast linear space, and we don't regulate that space. So in those instances, you would have to obviously go to the particular broadcast legislative provisions that deal with those. So whether it's the ECTA Act, ECT Act, or ICASA's provisions in particular, that's where you would then engage. You would engage with those institutions. But we only deal with VOD platforms, so it's video on demand platforms. So in essence, it would be, for example, where you have recorded your sermon, and let's say, for example, you want to use the YouTube platform as a way of distributing your content, that would fall within our mandate. However, the YouTube platform it falls within our current online distribution agreement with Google. Google is the overarching company that owns and runs the YouTube platform. And because we have an agreement with them, you wouldn't have to then meet the registration and classification requirements if you use the YouTube platform. If you have your own platform and you want to place that content on your platform, you would then have to then consider the issues that are raised about whether you are transacting, whether you are paying a subscription fee, or somebody has to pay a subscription fee to access the content, or if you're pasting adverts on your platform in order to secure revenue. That's a discussion you would have to have with us, because then you may fall within our legislative scope, and you would then need to ensure firstly that you're registered with the FPB and that you have classified that content for the purposes of ensuring that your consumers know what the age rating and consumer advice is for any of the content that appears on the platform.
So, Pandeli, essentially, if a church records a video of a sermon and it loads it onto YouTube, they don't have to worry about that, even if they share the YouTube link later to Instagram, Facebook, what other social media site it might be, or even on the church's own website. Because Google would already self-classify it as being, all ages, PG, 13, whatever. But should a church load that video onto its own website, and it should charge money for it? So as soon as there's money changing hands, it becomes a commercial transaction, whether that money is from advertising revenue or so forth. They need to contact the FPB and tell them the situation, and they might be required to register. Now, that brings me to my next question, which is, say that this is the case, that the church is loading the video onto its website and it's asking money or getting advertising revenue from it. Can the church apply to the FPB for an exemption?
It can. So let me just backtrack a little bit and just highlight the issue with YouTube. So I would always request, and yes, because I'm a technocrat, right? So even if the religious institution is going to be using YouTube as the platform, please always just touch base with us and just make sure that that is the case, because currently we have an agreement in place with Google, which again covers the YouTube platform. But you would always want to make sure that that is the case, right? So let's say in the near future where that's not the occurrence and maybe YouTube doesn't fall within an online distribution agreement, you don't want to then say, but I just solely relied on the advice that you heard today, where currently there is an agreement in place. So just to make sure that in the future that is always the case, just touch base with the FPB. FPB will always advise our distributors or prospective distributors that is the case, and then they will be covered. So as long as they do that, should always be good, right? So, and then the second part of your question, right, regarding exemptions, please always know that even though those are the current legislative and regulatory provisions that are in effect, right, and nothing prevents a prospective distributor of content to make use of the exemption provisions that are in our Act, right? Whether it is Section 22 or Section 23 of our Act, and again, I'm going to have to be a bit technical because there is a distinction between the two, but let's just term those broadly as the exemption provisions in our legislation. Nothing prevents our distributors from engaging with us to say, well, beyond knowing that I'm required to register and ensure my content is classified, can I lodge an application to be exempt from those provisions, right? In essence, it's a long drawn out process. I'm not going to go too technical about what you're requesting exemption from, but it's an application where you can request the FPB to say, I'm not going to hold you as the prospective distributor accountable in terms of not meeting what is required to either be registered or ensure that the content that is appearing on your platform is going to be classified, right? You'd have to obviously make a motivation. You'd have to show why there's good cause, why that exemption should be granted, and you have the ability to do so. That's firstly in the sort of Section 22, Section 23 sort of exemption provisions process, right? Also keep in the back of your mind that we do have certain regulatory provisions where you can even apply for an exemption. It's currently also contained in the regulations that recently came into effect. And you can do so, it's not only on religious grounds, there's quite a number of grounds that you could use to be exempted, right? But that exemption would very much push you in the space of not necessarily getting a broad exemption, but it exempts you in the space of being subjected to full classification for the content that's going to be appearing on your platform. So in other words, you may have to then pay a lesser fee than you would have in a normal course. But in either one of those two instances, exemptions can be considered. Exemptions can be applied for as a prospective distributor where you fall in either one of those two spaces. And of course, as long as you can show good cause and there's good grounds upon which you feel that the exemption should be considered, that application can be submitted, and the FPB will obviously apply its mind to it, and hopefully where there is good cause shown, be able to grant such an exemption.
I think that's a very fair and reasonable balance. I mean, obviously, I think the constituency that we represent, that's their primary concern. They don't want to find themselves delayed in distributing content because often that message is a very current one. They also don't want to be unduly, let's say, inhibited from having to apply for classifications for, things like, I was thinking, for an instance, I've just come back from a conference and they ran a series of lectures at that conference. And there may be that, and this is just a for instance, obviously if that's free of charge and they put it up on YouTube, then there's no problem with that. If they had broadcast, if they had broadcast that, let's say on an ongoing basis and they live streamed it, no problem with that. But if they were then to package that and put it up and make it a subscription issue that you had to pay, say, 100 Rand to download or access these videos, that's the point you're saying that they would potentially come into contact with the FPB and need to find some classification.
And I think in that instance, right, again, I think it would just be on the basis that, again, it wouldn't be limiting people's ability to access that content on the platform. It would just mean, firstly, being subjected to having to register as a distributor and making sure that you properly are registered. But beyond that, classifying those titles. So those sermons would then be classified and would receive a classification rating so that anybody who wants to access any one of those sermons would just know what age rating would be allocated to it, right? And I think for in that premise, it would just then be the ability for your prospective consumers of content to just know what the age rating and the consumer advice that would be applicable, so that when they're making a decision about who's in the room watching the sermon, they can make that informed choice, right? So sometimes the content that is being distributed on platforms may not necessarily be content that all children will be able to consume. Sometimes it may be content that requires a possibly sort of higher age rating, anything from a 7 to 9 PG to a possible, 16 age rating. And of course, it just depends on what is appearing on the particular title. But once it has been allocated to the content, it just means your consumers can make informed choices about who can watch that particular sermon. And I don't know if you want me to give you an example of a recent instance that we've had to engage with our prospective distributors. So in the exemption provisions in our regulations, we have received DVDs. Yes, I know a lot of our younger consumers of content would ask you the question, what is a DVD? And I'm happy for you to have an explanatory note at the bottom for all our younger consumers to tell them what DVDs are. But yes, they did exist in the past, right? So there was a DVD of sermons, right, that were being appearing. And what we were doing in that exemption application process when we were classifying it, the producer of that content, what they were doing is they would have cutaway scenes to a particular film, The Passion of the Christ, right? And in that content, you would see rather graphic details of the violence, in essence, that was being inflicted on Jesus Christ, right? With a lot of bloodletting, a lot of scarring, a lot of pain that you would be seeing in that instance. And clearly that content, in essence, was intended for older audiences, right? It's older children that would be able to consume it. So automatically what had to result then is we had to give a higher age rating to the sermon, not because of what was being preached in the particular sermon, but because the cutaway scenes were showing those images from that particular film. It meant that younger audiences would not be able to consume that content. So it's in those instances where we would have to obviously classify the particular sermons, and where you've introduced such content in a particular title, it would warrant a higher age rating. And thankfully, I think it would assist your consumers of content to know what younger audiences can consume.
Yeah, I think that's an interesting one. I mean, I think just to go back, if that message had been, let's say, live streamed with those cutaways involved in it, then that wouldn't have been caught in that net, number one. And number two, if they put that up on YouTube and they just made it, free to view, then that also wouldn't fall into the categorization that you mentioned.
It wouldn't, but what I can advise you is, and let's use, because again, remember, live streaming is not our mandate. You would have to engage with the other regulatory sort of instruments that would be applicable in that space. But let's use YouTube. YouTube's artificial intelligence, its systems would automatically have identified the fact that there's certain images that are appearing on the content, and then would give consumers of contents warnings about what is going to appear. So even in that instance where you wanted to access it as a YouTube title, it would already give you the warning as a parent, as a guardian, to say that there is content that's going to be appearing here that, besides for the sermon itself, would require you to be more cautious as a parent and make sure that you don't have younger consumers of content present so that you can ensure they're not going to be exposed to harmful content that they should be seeing as a younger age, especially for those younger, more impressionable children.
Wonderful.
Pandeli, thank you so much for your time. So just to conclude, if complaints are laid against religious speech, the FPB will investigate it. How they will judge it is still to be determined, but so far you will be bound by constitutional court jurisprudence that came out in civil matters like Welani. So because the Amendment Act criminalizes it, one could argue that even narrow grounds needs to be adopted, but the FPB is still in the throes of navigating that, and 4SA will remain actively involved. When money changes hands for content online, churches need to look at whether or not they need to approach the FPB for an exemption, which they can do, and we'll refer churches down to their FPB's website and the link below this video. And finally, you are the Films and Publications Board. So what does this mean for articles and blogs that get posted on religious organizations' website? Are they subject to pre-distribution classification?
So you mentioned so many things, Daniela, so I'm going to deal with them one by one, right? So the first one is pretty much on point with regards to how we will prospectively be dealing with complaints where, for example, the allegations are going to be made related to hate speech. What we're going to try and do, obviously, in our space is because the ability to present matters before the enforcement committee that, in terms of allegations or complaints that fall within our expanded mandate, we will be obviously dealing with those in terms of firstly complying with due process. So due process means we will have to investigate them as the FPB. Where we feel on a balance of probabilities a case can be presented before the enforcement committee, will do so. And in making that assessment as to whether content, for example, amounts to hate speech, and again, it could be in any one of those instances where it may amount to hate speech, we will obviously look at the jurisprudence that has been developed in our courts to make that assessment. Ultimately, however, it's still a determination that the enforcement committee will make. They're an independent objective body that makes that determination. And even if they have made that decision, and let's say on a balance of probabilities, they feel that hate speech is there, I think it's important to share with your stakeholders that you even have the ability to challenge that decision before the appeal tribunal. So even if you do feel that the enforcement committee's decision is not a correct one, you have an opportunity to even escalate it to the appeal tribunal, who would likewise be able to make that determination, just to give a more fuller picture in terms of the processes that would be followed in that space. Did you want to come in?
Yeah, so just to use a practical example. So say, you know, Sunday sermon talks about something that could be politically offensive. Someone lays a charge of hate speech against the pastor or the church with the FPB, goes to the enforcement committee. The enforcement committee is going to evaluate it on the civil standard of a balance of probabilities and decide whether or not the church needs to take down the sermon. But the National Prosecuting Authority will then decide whether or not to actually prosecute the case of hate speech, because the Act does make hate speech a crime. And I know we've had tussles before on the definition of hate speech there, or say arguing for a narrow definition. But then the matter will be decided on the criminal standard of beyond reasonable doubt. And even in the enforcement committee's side of the matter, of where the only penalty that could come out of there is, for example, a fine or being ordered to take it down, the enforcement committee will decide it in line with the constitutional court jurisprudence coming out of Welani, where, for example, offensive speech is not prohibited.
So importantly, and I think you've just raised a very important issue, right? So the enforcement committee cannot, it's not a criminal court, it cannot hand down a criminal sentence. What it has the ability to do, because our offenses and prohibitions provisions in the Act allow for it, is it can make a recommendation when it feels it should do so, right, to the NDPB, right, for it to consider dealing with that matter in terms of its own criminal proceedings, processes, and procedures, right? So the enforcement committee cannot hand down a criminal sentence. It can merely make a recommendation to the NDPP that it should do so, right? What it can do is impose a fine, the penalty of a fine, like you said, in addition to issuing a takedown notice. And that's what it does have the ability to do. So it cannot impose that, it cannot hand down a criminal sentence. So in dealing with the issuing of a fine where it feels it is an appropriate award to grant, that is based on a balance of probabilities. And of course, that's where a case will be presented to the enforcement committee to say, on a balance of probabilities, the view is that there has been a contravention in the provisions in the Act. And on that basis, the enforcement committee should consider it as such and ultimately make a decision. The respondent has an opportunity to also present its case. And it's in balancing those two issues that the enforcement committee hopefully will then become, it'll make its own fair and objective decision as to whether the case has been adequately presented and whether it can do so. So it's always in those instances that the enforcement committee will deal with those situations.
And just quickly turning to the question of the pre-classification of
publications. Yeah, so the Act, the Films and Publications Act, does distinguish between two instances. The one in section 16 deals with publications, and on the other hand, section 18 deals with films and games. Publications are not subject to pre-distribution classification, importantly. And when we deal with publications, it's always important to note that there are two issues that we will always consider. Firstly, if you're a member of the Press Council of South Africa, or if you're the member of the Advertising Regulatory Board of South Africa, you're specifically excluded from applications. So we will never deal with any matter where you are a member of either one of those two organizations. So that's a specific exclusion. But with regards to pre-distribution classification, which publications are not subjected to, there is an exception, and that is where your content, your publication content contains either propaganda for war, incitement of imminent violence, or hate speech. So in any one of those three instances where your publications contains any of the three, right, then it is subject to pre-distribution classification. And again, it's not subject to censorship. It just means prior to it being distributed, make sure that you've submitted it to the FBB for the FBB to classify the content, and then it can appear on any platform that you intend to distribute it, because then it would have been classified, right? So for example, let's say you gave us the example of it's a blog and it's a religious blog, and your stakeholders frequently put their blogs up for consumption. By the way, a blog, even on an online platform, is a publication in terms of our Act, right? It just means it would not be subject to pre-distribution classification. However, only where it does not contain incitement of imminent violence, propaganda for war, or hate speech. So where the blog does contain any one of the three, please ensure that you have submitted it to the FBB for the purposes of classification. Again, it will not be censored. It would not be blocked. It just means it has to go through the classification process prior to being distributed to the public.
So I have a quick question here for you. So propaganda for war, incitement of imminent violence, and hate speech are all prohibited content, which the Amendment Act prohibits. So in terms of that, appearing in a publication and appearing in a film, if that appears in a film, so for example, in a sermon, goes to the Enforcement Committee for Investigation. Enforcement Committee can issue a takedown notice, impose a fine, might refer the matter to the prosecuting authority. And in terms of a publication, it's still prohibited content, yet you're saying refer it to the FPB for classification?
Yeah, you have to deal with it in its technical guise. And I'm so happy you asked that question, Daniela, because let's deal with it technically, right? It's publication in the space of you being a commercial distributor, right? So for example, let's say you do have a blog, right? And your blog generates some sort of commercial transaction, right? Then it's not subject to pre-distribution classification. However, where it does contain propaganda for war, incitement of imminent violence, or hate speech, then it has to be submitted to the FPB for classification, right? So that's how you would trigger Section 16. Where, however, there's no commercial transaction. So in other words, you're just putting your blog up and there's no advertising revenue. Nobody has to pay a subscription to access your blogs that you're going to be putting, or nobody has to pay a particular fee to access any one of the blogs that you're putting up. Then in that instance, there's no commercial transaction that's involved. And that's where, if your content would fall within the definition of prohibited content, then a member of the public can complain. And that's when it's going to be subjected to the investigation. And if a case has to be met, be taken up to the enforcement committee. So it's where you fall within any one of those two categories. Are you a commercial distributor? And therefore Section 16 will apply if you fall within that space, or where you don't, then you would fall within the expanded mandate of the FPB. And I know it gets very technical, so I must apologize, but you have to just be able to be comfortable with both and know when those provisions kick in.
Well, Pandelis, I just want to say also thank you, particularly for the way that you have liaised with and worked together with 4SA over this developmental season, and also I think for making sure that the concerns of the faith community were not only heard, but I believe recognized in the outcomes that have actually resulted, so that there's a balance between obviously what view government are trying to achieve in terms of obviously protecting the more vulnerable of society, while at the same time allowing and making sure that, you know, particularly freedom of religion, that freedom of expression can be broadly maintained without any form of undue interference. So we just want to thank you for your engagement with us, and thank you for your time during this interview.
Well, thank you to you, Michael and Daniela. All I can share in addition to that is, please, whether it's 4SA or any one of the institutions, organizations that you work closely with, religious or not, they should always feel welcome to engage with us. We're always open to having those discussions and explanations with our stakeholders. And what I usually request, and it's a very humble request, that where any organization or institution feels that they're a bit confused, they don't know whether they should or shouldn't be registered, or, you know, does this fall within the legislative scope of the FPB, please feel free to engage with us. We're happy to have those discussions. Whether 4SA also engages with us together with them, if that's a request that they want to convey, please always feel welcome to engage with us. We're happy to engage with your stakeholders. It's better for us to have those discussions right at the outset, before, you know, the FPB engages in a process where you know, a lot of the stakeholders usually say, you know, it would have been a lot better for us to have had these discussions right at the beginning, as opposed to now feeling rushed in terms of where you do fall within our legislative scope, having to do all of these administrative steps beforehand.
And again, the big trigger is when money changes hands, then you become a commercial distributor, according to
exactly. But Daniela, the $1 million question is, let's engage with your stakeholders so they know what a commercial transaction means, so that there's no confusion, so you're not going to have any challenges. So that's why we're happy to have that discussion, and hopefully we can assist wherever we can.
Wonderful. Well, thank you again so much, Pandelis, and really appreciate all the help that you've been, and thank you for giving us your time and all these insightful answers.
Thank you.
Good day. This is Daniela Ellerbeck, the Legal Advisor to Freedom of Religion South Africa. Remember to like and share this video, and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.